The child support system is complicated. There are at least 4 different acts of parliament and 5 different sets of statutory rules that govern it. It's very easy to become overwhelmed by it. But just remember that the KISS principle applies in child support cases, the keep it simple, stupid principle. If you're in court arguing before a difficult judge, or if you're trying to make your case before a difficult member of the Administrative Review Tribunal, or if you have encountered a difficult member of the Child Support Agency when dealing with him or her, just remember to quote this KISS principle. Now, the higher courts have been at pains over the years, in fact centuries, to make the point that child support cases need to be dealt with a great degree of informality. The KISS principle, essentially. One of the more useful cases to cite in that regard is a case called O'Hara and McGuinness. Now, O'Hara and McGuinness was determined in 1990, and it's reported at volume 14 of the Family Law Reports. And for those of you who have access to a law library, you will see that case is reported at page 723. Now, page 724, the learned judge had this to say about the KISS principle. The Act, and he was talking about the Child Support Assessment Act, shows an intention to determine the question by considering not the legalities which would otherwise apply, but what might be called the real justice of the case. And this is a principle that goes way back in time, way back before the Family Court of Australia came into existence. And a good example of that is a case from the Supreme Court of Victoria in 1964, a case called Davis and Davis. It's reported at in the 1964 volume of the Victorian Reports at page 278. At page 280, the learned judge, Mr. Justice Barry, in that case said this: a judge should show a degree of practical wisdom, refusing to be misled by appearances and look at the reality of what is going on in a particular case. Now, a couple of years ago, I wrote an article for the Family Law Review on this issue of informality in child support litigation. It's reported in volume 5 of the Family Law Review. And for those of you who have access to a law library, you will see the case is, or the article is written and reproduced at page 185. For those of you who don't have a law library, of course, all these cases can be accessed on the OSLI website. So what does the KISS principle mean in practical reality in terms of day-to-day child support litigation? It means, in my own language, stick to meat and potatoes. Stick to simplicity. If the other side or the tribunal member or the judge is starting to descend into all sorts of technical detail, focus on what's really important in the case. How old are the children? What do they really cost to support? What's your income? What's the other side's income? Or what is at least the other side's capacity to earn? Focus on those practical realities and it should help you a very great deal. I'm Simon Bacon. I was a child support lawyer for 35 years. And if you're interested to find out more about this topic, have a look at my website, childsupportlawyers.com.au.